Hello again, Stephen A. Walvick from the law offices of Stephen A. Walvick. In this short video, I talk about how to file a request for order for child custody and visitation in California. So to get temporary child custody and visitation after the case is filed and before a trial or settlement, you file a request for an order. Now this form tells the court what orders you're asking for, and you have to prepare a declaration to support your request. So what is a declaration? Well, I've included a dictionary definition. It's the act of making an official statement about something. Here's what it is in a family law case. It's simply your story, signed under penalty of perjury, to support the request that you're asking the court to order. This next slide breaks down the contents of a declaration, what each declaration should contain at a bare minimum. So the first is quite obvious. It should have your name. It should also state what role you occupy in the case. You're either the filing party, the petitioner, or you're the responding party, the respondent. Your declaration must contain the name of the children and their dates of birth, because the court may make different orders for a 13-year-old versus a 6-month-old. Your relationship with the other party and the history of your relationship with the other party are also important. You're going to describe whether the other parent was married to you, whether you just had children together, were you ever living together, is the other parent on the birth certificate, if you are living together currently, how long were you living together, how long were you apart. Your role as the caretaker for the children. This is really important. Who does the cooking, the cleaning, gets the children ready for school or daycare in the morning, takes them to their doctor's appointments, to the daycare, to the school, helps them with their homework. All those things describing your role with the children is essential. The visitation schedule since date of separation, we attorneys like to call the status quo. If you're not living together and you've been separated for some time, what has been the visitation schedule? Courts are not usually willing to change what parents voluntarily do with respect to visitation with each other. What has been the history? Now, if you just recently separated, you may not have that history. But if you've been separated for a year and a half and the one parent only sees the children on alternating weekends, it's going to be very difficult for that parent now to come into court and say, I want 50% visitation time. The other parent's involvement with the children is also important. So you not only want to express what your role's been as the caretaker for the children, but what has the other parent done or not done? And finally, the orders you're requesting the court to make. You have to express very clearly what do you want the court to order. So now let's talk about custody. There's two types of custody. There's legal custody and physical custody. We're going to focus on legal custody. Legal custody is the right of each parent to make health, education, and welfare decisions for their child. So no matter how contentious the divorce is, no matter how much you may dislike the other parent, you both have to work together for the benefit of your children. Most parents in California get joint legal custody. That means they have to work together until the child turns 18 or graduates high school. There are instances where one parent would get full legal custody. In those situations, the other parent either has a history of domestic violence, drug addiction, prison, something that disqualifies that other parent to be shown to be able to make those important decisions for the child moving forward. So now let's talk about physical custody. Physical custody, I usually term in the way of a visitation order. Where are the children physically going to be with each parent, when, and how? So let's talk about what goes into visitation orders and what you can expect. So the purpose is obvious. It sets a schedule when each parent's going to see the children, but it does so much more. It sets transportation rules. Who's going to do the driving for the pickup? Who's going to do the driving for the drop-off? And where are those points of exchange going to be? In contentious cases, it could be the police station. In cases where the parents can get along, it may be at their residence or it may be at the children's school or daycare provider. A visitation order is also going to set a holiday and vacation schedule. So who gets the Monday holiday following that parent's weekend? Who's going to get Christmas Day, Christmas Eve? How is Thanksgiving going to be divided? School vacations and work vacations when you want to go away with the children. Visitation orders can also require notification to the other parent of any change of address, work, school, or phone number, because it's important that you know where your children are even when they're not in your custodial care and how to get a hold of the other parent. Visitation orders can condition rules regarding childcare, making sure that the children are not left with underage supervision and that the other parent knows the name and location of the daycare provider. Visitation orders also set very important rules regarding cancellation of visitation time. So what happens when one parent's late to the pickup or the exchange point? When can that visitation be canceled? Also, what if the children are with one parent and they're sick? What notification has to be given to the non-custodial parent that the children will not be able to make that visitation time because of illness? Visitation orders also set conditions on telephone contact with the non-custodial parent. So let's assume the children are with parent A and parent B wants to talk to them and say hello to the children. A telephone contact order can specify what time those calls should take place so the parent with the children can expect that phone call during those hours. Now, visitation orders also can have restrictions, restricting negative comments about the other parent, restricting discussions about the family law case with the children. Remember, the children shouldn't be involved. They shouldn't have to pick sides, and they shouldn't be involved in the divorce. It's hard enough on them, so putting them in the middle of the case is just so much worse for the children. Visitation orders can also restrict children from being exposed to cigarette or medical marijuana smoke. And it also can require each parent to maintain clothing for the children when in that parent's custodial care. So now let's get back into the process. So you filed the request for an order. You're asking the court to make a custody and visitation order regarding your children. Before the court will even talk to you, the court's going to make it mandatory that you talk to a child custody mediator. Now, in some courts, that's a confidential process. You can say anything to the mediator about the other parent, and it doesn't get back to the judge. In other courts, the report from the mediator goes to the judge. So whatever the parents say, the mediator will listen to, and the mediator can make a recommendation to the judge. Just depends on the jurisdiction your case is set at. What happens in mediation is a mental health professional, marriage family therapist, or some other professional is going to work with the parents to help the parents craft a visitation schedule. Let's face it, it's much better if the parents themselves set when they're going to see their children, if at all possible. Because if the parents cannot decide, then the court's going to make that decision. The judge in your case, doesn't know you. They're reading your declaration, and that's the only exposure they have of your parenting skills and your comments about the other parent's parenting skills. And that judge now is going to determine when you get to see your kids, instead of the parents working it out together. So if possible, I always urge my clients, be diligent and work as hard as you can to come up with your own order, something that you can live with, that you and the other parent can craft because they're your kids, as opposed to leaving it to the person sitting on the bench. All right, so now let's talk about, going back to the beginning, how do you prepare your papers? So many people in court file their own paperwork, and they use paralegals or non-attorneys to assist them in the preparation of their documents. Here's the problem with that. If the person helping you prepare your papers is not from the self-help center of a court and is not an attorney, they cannot help you pick what forms you should file. They cannot help you with what you should say in your paperwork. They're supposed to just listen to you tell them what to do. You're supposed to tell them what forms you want filed, and you're supposed to tell them what you want to put in your story. If they do anything beyond that, they're practicing law without a license. So in that case, if you can't afford an attorney to help you with your papers, use the court's self-help center. Each court has a self-help center. They'll help you pick the right forms to file, and they may even give you some guidance as to what should be in your paperwork. But that's a court-sanctioned body, not some paralegal trying to make money and capitalizing on your situation for their own financial gain. My office offers both types of services. We offer full representation and will also help you simply prepare your documents for you to go to court and argue your case yourself. So we act like a paralegal service, but you get the benefit of a quality attorney giving you help, telling you what forms to fill out, telling you what should go into your paperwork, even if we're not appearing with you in court. To schedule a free no obligation consultation with my office, click the link on this slide. Go to our worksheet tab and fill out the family law worksheet. Use the telephone scheduler on our website and schedule your free 30-minute telephone consultation and have a conversation with me personally. Otherwise, feel free to simply call me at the toll-free number in this slide. I hope you find this informative, and I wish you the very best of luck in your family law case.